Okay, you had been shot in this event?
I did myself on accident.
Judge.
It says several gunshot wounds to your left leg.
Yeah,
You shot yourself more than once?
it went through my knee and it hit me in the foot. That's
Okay.
I think it was just one.
It says lying on the.
All right, pause right here. This is already wild. The defendant claims it was an accident, but listen closely. Multiple gunshot wounds, different entry points. In court, details like this matter because accidental discharge becomes a lot harder to sell when the story doesn't cleanly line up. Do you think this sounds believable so far?
Ground with several gunshot wounds to his left leg.
Yeah.
Yeah, but it's always a good idea to go to get some training on firearms use before you go out and shoot yourself.
Yes, sir.
And there it is, the judge's subtle sarcasm. That line about firearms training isn't just humor, it's a warning. Judges often use moments like this to signal accountability without directly escalating punishment. It's light, but the message is serious.
Yes.
Okay, so he's got unlawfully carrying a weapon at a prohibited place in 23. That was this then, right? Yeah.
Yes.
Okay. That's looks like the only criminal history.
That's great.
Okay. Here. All right. Does the
This part is critical. Notice how the judge reviews criminal history before anything else. When a defendant has limited prior offenses, it can work in their favor, but only if they follow the rules going forward. And as you'll see, that's where things start to fall apart.
we call 22-39919 Ezekiel Emmanuel Johnson. There is a first amended motion to revoke unadjudicated probation. Mr. Johnson is here with Ms. Minaldi, her attorney, and the state's attorney. Does the defendant waive a formal reading of this first amended motion to revoke probation? Can we proceed in sign?
Yes, Judge.
And sir, please raise your right hand, Ezekiel. Do you solemnly swear or affirm any statement you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your hand. In summary, this states that on April 6th, 2023, you, in this court, you were placed on 5 years deferred or unadjudicated probation for the third-degree felony of unlawfully carrying a weapon in a prohibited place. Is that correct?
Yes, sir.
You know, it's a place that sold more than 50% of its supply of goods and alcohol-related items. First amended. Can we do number 7, bail jumping?
Sure, Judge.
Okay. Allegation 7 states you committed the offense of bail jumping on or about March 5th, 2024 in Jefferson County, Texas. In Nacogdoches County, Texas, which is in violation of condition 1 of your deferred or unadjudicated probation order. Is that true or untrue?
Yes, sir. Yes, sir.
And then finally, number 8.
Let me break this down simply. Deferred or unadjudicated probation is basically the court giving you a second chance. You're not convicted yet. But violate even one condition, and the court can sentence you as if that chance never existed. This is a legal tightrope. Defendants walk.
States you failed to report to the Jefferson County Probation Office for the months of December 23, January, February, March, April 24, etc. Was he an absconder for all?
Yes.
How long?
About 2 years.
Hello. Where you been?
I was homeless and in the jail at the time.
2 years as an absconder, that's not missing paperwork. That's disappearing. Judges view failure to report as one of the most serious probation violations because supervision only works if the court can actually supervise you. This moment right here seals his fate.
My court probation department was June 8th, 2023.
You have to report. If you can't do anything else, you got to report it. You are not on really supervision. You're on your own supervision, which is not the way it works. You have to report. That's really the easiest thing to do, but that's what gets you in trouble. Because that's really the most important thing. It's all about supervision. All right. Are you pleading true to allegation 8, failing to report to the probation office as this states in violation of condition 4 of your deferred or adjudicated probation order? Is that true and correct?
Yes, sir.
So are you pleading true and correct to allegations 7 and 8 voluntarily, knowingly, intelligently, and because those allegations are true in this first amended motion to revoke unadjudicated probation filed on July 25th of 2024?
Yes, sir.
Do you understand that one or more violations of probation proven by a preponderance of the evidence or greater is enough to grant a motion to revoke probation like this one? Your probation can be revoked. You can now be found guilty and sentenced to no less than 2, no more than 10 years confinement in prison.
Yes, sir.
Knowing that, do you insist on pleading true today?
Yes, sir.
And this is a turning point. The judge explains the consequences one last time, up to 10 years possible, and still asks if the plea stands. This is about informed consent. Once the defendant says yes here, the outcome is almost locked in. Would you have taken this deal?
I find you were pleading true voluntarily to allegations 7 and 8 of this first amended motion to revoke unadjudicated probation. You understand and appreciate the consequences of pleading true.
Yes, sir.
Okay, what are we doing on?
2 years TDC.
Do we have an agreement?
Yes, Your Honor.
I don't have a pen. An agreement's been reached here where your probation would be revoked. You would be found guilty beyond a reasonable doubt of this underlying offense of unlawfully carrying a weapon in a prohibited place, a 3rd-degree felony, sentenced to 2 years in prison. Is that your understanding of the agreement?
Yes, sir.
And then we've got all of these numbers here, plea of true to number 2, which is not what we did.
No, we can change that to 7. Judge.
It takes 5 seconds after you put something on it for it to show up on the pen. We're getting these changed soon, they say.
The new ones are here, Judge. They just programmed them. So maybe it'll be under the Christmas tree. And it's for you.
Heard that. I've heard that since I was a young kid. I've learned. There's some tomfoolery going on.
Honestly, the nice.
Okay, so allegations 7 and 8 of the MTR motion to revoke probation first amended. You have pleaded true to allegations 7 and 8 voluntarily, knowingly, intelligently. I find that supports the first amended motion to revoke unadjudicated probation in this case, to grant it by a preponderance of the evidence or greater, and your deferred or unadjudicated probation is hereby revoked for this that he found. Earlier in this case, you had pleaded guilty to this indictment voluntarily. You were mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of that underlying the crime of unlawfully carrying a weapon on a prohibited place, a 3rd-degree felony. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 2 years. I'm showing you what's marked as State's Exhibit 1. Did you sign all of that? Understand it? Discuss it with your attorney? Is everything true and correct? If State's Exhibit 1 is tendered into evidence without objection, among other things, this states that you are waiving all rights of appeal if I follow this agreement. I've done that, and you have no right of appeal. You will be given credit for all time you have served in accordance with this case. Do you understand what's happened today, sir? Anything else?
No.
That is all. Thank you, Melissa.
Thanks for watching. If you enjoyed this video, don't forget to subscribe and hit the bell icon so you never miss the most dramatic and real courtroom moments. Your likes and comments mean a lot. Share your thoughts below. See you in the next video, and stay tuned for more courtroom drama.